Hello everyone, this is Dr.P.Syamala from the Department of MBA, IB, Nagarjuna University. And coming to our topic, in previous class we have studied about the rules, rules of SCRA Act, SCRR, Securities Contract Regulation Rules. Up to this, up to section 19 we have completed. Now if we see 6 of section under 19(6), 6A, 7, 8, all these are related to the recognized stock exchange may either at its own discretion or shall in accordance with orders of SAT restore or readmit to dealings in securities suspended or withdrawn. This is under 19 subsection 19(5). So actually we are dealing section 3, section 4, section 5. So these are about, section 3 is about application, section 4 is about grant, and section 5 is about withdrawal. Under this withdrawal, section 5, withdrawal of listed companies under RSE, we are talking about this point. A recognized stock exchange may either, so after withdrawing by the recognized stock exchange, it may consider, but at its discretion it may or it may not admit that company, or else in accordance with orders of SAT also it can readmit the dealings of the securities of that particular company. And 6A tells under this section 5, withdrawal, except as otherwise provided in these rules or permitted by SEBI, all requirements with respect to listings prescribed by these rules shall, so far as they may be, also applied to public sector company also, according to the Act, SEBI Act, are provided under the rules of SEBI Act, it can be applicable to the public sector company also. Then SEBI may its own discretion or on recommendation of RSE, it may waive or relax the strict enforcement. It may take off or relax the enforcements, through the recommendations, or else through the recommendations of RSE, SEBI, SEBI will have discretion, because after central government we have SEBI, after SEBI we have stock exchange. So SEBI has extraordinary powers, and by the recommendation of a recognized stock exchange, it may waive or it may relax the strict enforcement of that company. Now last one is, notwithstanding anything contained in this rule, the minimum offer and allotment requirements as prescribed under clause of sub-rule shall not be applicable to the listing of such equity shares having superior voting rights issued to the promoters or founders, as the case may be. So minimum offer and allotment requirements will be there according to the clause B. So for those it shall not be applicable to listing of such equity shares which are having superior voting rights. So now coming to rule 20. All the above is regarding the section 19 rule. So we have discussed many aspects under section 19(1), 19(2), and we have conditions also. Conditions are discussed under rule 3, under 19. So all those can be again discussed in the listing of securities. Now coming to rule 30. So what does rule 30 means? So requirement with respect to the listing of units or any other instrument of a collective investment scheme on a RSE. So units we all call in a company. If at all the company want to raise capital, what company will do? It will go for public issue. Public issue means it will purchase, it will sell its shares. So likewise in collective investment scheme also, we don't call them as shares, we will call them as units, okay, under collective investment scheme. So this collective investment scheme means like they will collect some amount of money, they will pool some amount of money from different investors, okay, from different people, and they will invest that that amount in other activities, okay. Why? Because to gain profit on that amount and share that amount to those investors or to those persons. So that is collective investment scheme. So here we will not call them as a shares, we will call them here as units, okay. So under collective investment scheme we call them as units, okay. So the main motive is to gain profit on investing that amount in other activities, okay. So for that also we have regulations, the regulations of stock exchange, SEBI, the central government, etc. And coming to section 20 subsection 1 rule, okay, under 20 we are studying about different subsections, and all these are related to, we have studied in listed company, you know, the conditions, or else about the listing of companies, application of companies, granting of a company, or else withdrawal of that company, everything, each one is same to same applicable for this collective investment scheme also, okay. So as I said before, as I have explained already in listing of securities, okay, the same aspects will be repeated here, okay. See, for example, a collective investment scheme management company which is desirous of getting its CIS, collective investment scheme, listed on RSE shall apply for the purpose to the stock exchange. The same aspect there also in listing of companies also, company has to go for apply for the RSE. The same aspect here also, we are, the CIS has to, the name only we will change that, there we will see company, here we will see collective investment scheme, there we will see shares, here we will see as units. That is the difference, but the same, everything will be similar only, okay. So here likewise, that's why I have given here, same will be applied, okay. All the conditions regarding the listing of companies, the same will be applied here also, regarding the memorandum of association, articles of association, everything will be here, okay. So likewise, apart from complying with, they have to go for application, they have to comply with the rules and regulations. 25% of units should be there offered to public, okay. There also in shares also we have there 16,000 crores for 25%, okay. Likewise here also 25% of units should be offered to public through advertisement, okay, for a period of not less than 2 days and more than 90 days, okay. And a company applying for listing of a scheme shall as conditions. So conditions we have seen there. For listing a company, what are the requirements, what are the conditions under section 319 subsection 3 we have studied now. So those conditions will be applicable here also, okay. So likewise, a fresh application for listing will be necessary in respect of all new schemes. If at all we have seen in company, if at all they are going for new shares, means again they have to go for fresh application. So likewise here also, for fresh application for listing of is necessary for new schemes desired to be dealt in. So units are identical only if they are issued under the same scheme, same nominal. So all these can be seen the same. Again we are going for fresh application. So therefore the units should be identical, the same scheme should be used, same nominal value, amount, rate of return, everything should be same, okay. And RSE may be suspended or withdrawn admission to dealings, the same as company only. Here also RSE according to SAT restore readmit dealings in any units. So for example, if that particular CIS, collective investment scheme, okay, if at all it is not satisfied with the RSE that it is suspending or withdrawing the admission of this CIS, okay, in order not to deal with, then if at all it is not satisfied the CIS, then it can go for appeal to where, means SAT, Securities Appellate Tribunal, to restore its dealings, okay, or else to readmit their dealings in any units. Likewise, seventh point is all the requirements with respect to listing prescribed by these rules shall also apply to a body corporate constituted by an act of parliament, any state legislature. Okay, the same aspects. Likewise, SEBI also its own discretion. SEBI has its own discretion to recommend. Okay, by the recommendation of RSC. Okay, then it can waive or it can relax the strict enforcements on the dealings of the CIS. Now coming to rule 21. Okay, so under 21, delisting of securities. Okay, see here, previous this is rule 21. Now we are studying about 21. Previous is 20 and now is 21. So 21 is relating to delisting of the securities. Okay, so as I said before, listing of securities means we are adding the securities in the RSC. Now delisting means we are omitting this. Already it is in the listed as a listed company in RSC. Now we are deleting this. Okay, so a RSC may, without prejudice to any other action that may be taken under the Act under any other law for the time being in force, delist any securities listed thereon. Okay, so the recognized stock exchange may delist any company without any prejudice. Okay, so what are the grounds to delist a company? On what basis? What are the reasons to delist a security? Means company incurred, if at all the company incurred any losses, means maybe during losses during the preceding 3 years, before 3 years, consecutive, continuous 3 years. Okay, continuously from 3 years, if the company is incurring losses and they have the negative net worth. Okay, then RSC may delist that company. Or else, if the trading in securities of the company has remained suspended, means they are not trading for a period of more than 6 months, there is no trading, then also in such case also delisting can be made. Likewise, company promoters, directors, okay, all of them, any one of them has been convicted for failure to comply with any of provisions of the Act, or else SEBI, then also they are delisted. And if at all the person's address, company's address, director's address, promoter's address is not known, or else they have given false addresses. Okay, they have not given fully furnished information regarding the addresses also. So, or else if at all the company changes its registered office in contravention of the provisions of the Companies Act, then also company will be delisted. And D aspect is failure to comply and convicted by the company. So failure to comply the acts of laws and shareholding of the company held by the public has become below the minimum level applicable to the company as per listing agreement. So while they are applying for the RSC, at that time only they will give the list. So in if the company held the public, the shareholding of the company held by the public has become below the minimum level. So according to the agreement, it is not there, it is only minimum level, then they have to raise their public holdings, according to the listing agreement. If at all they have not raised, means within the time, then also delisted. Next, this is about section 21(1) subsection. Now 21 subsection 2. If security is delisted under clause 1, so then it is also delisted. So delisted under clause 1 means company or promoter or director of the company shall be jointly liable to purchase the outstanding securities from those holders who wish to sell them at fair price. So in that case also, if at all they have not taken any liability, or else outstanding securities are purchased, without not according to the provisions, then also delisted. Then B, the said securities shall be delisted from all recognized. So as I said before, all the said things will be undergone to delisted by the RSC. Now 21(3). So what does 21(3)? RSC may on the request of the company delist any securities listed thereon subject to following conditions. So 21(3), what it says means RSE, the recognized stock exchange, may on request of the company. Here the company itself requests that to delist their company. Okay, so why it asks means what are the conditions means here, if securities of company have been listed for a minimum period of 3 years. Okay, in listing agreement only they have written that our trading will be for minimum 3 years period only, then in such cases delisting will be done, or else delisting of securities have been approved by 2/3 of the public shareholders. Okay, the shareholders itself, they said that to delist the company with the majority of 2/3, then also delisting can be done, or else company promoter, director purchase of the outstanding securities from those holders who wish to sell them at a price determined in accordance with regulation. So if they have misleaded this, okay, if they have purchased the outstanding securities not according to the provisions of the act, and also delisted, then Form A, Form B, Form C, these are all the rules are completed. Okay, then if we go for Form A, Form B, Form C means, so how to apply? Okay, for application for recognition of a stock exchange. Okay, so how to apply? So for this we have part 1, part 2, part 3, part 4, part 5. Okay, so all these are different parts while we are going to apply for recognition of a stock exchange. So then what are the elements that we have to furnish means, first is general thing. In general we have to give our name, address, everything, and for membership we have to give our articles of association, that who are the members, who are the officials, what is their experience, who are the minimum numbers, minimum qualifications, procedure for admission, everything should be furnished. Likewise part 3 is about the governing body. Okay, so who are the board of directors, who are the members. Okay, so who are the representatives, what are the powers, what is the constitution, how the election is conducted, what is the tenure, everything will be discussed in the governing body. Okay, and for fourth one it is regarding the trading. Okay, trading kinds of contracts, how many business hours they will trade. Okay, or else the scale of brokerage, regulations, provisions, clearing house, about contracts, types of contracts, everything will be discussed under part 4. And part 5 miscellaneous. Okay, any machinery arbitration of disputes, regarding the requirements of admitting securities, everything will be discussed in the part 5. So this is through these forms only, okay, the companies will go for application. Okay, so in that application is divided into 2 parts. One is part 1 5 parts. Okay, and the 5 parts there will be general membership, about general information, about membership information, about governing body information, about trading information, and about miscellaneous information will be furnished with the stock exchanges. Okay, so these are about the rules of the SCRA Act.